job for you.
Hey boss, what you got?
Okay, well, we've got a pretty big name client in here. You know Thomas & Company?
Of course, who doesn't?
Yeah, they're huge. So Martha Fesser, their VP, was in here this morning trying to sue her doctor. Here's the notes from the meeting, but I'll kind of run you through it. Basically, her insurance policy is through the company and Qual Health, and they're set up with a capitation contract. You know what that is?
Yeah, of course.
Okay, good. So anyway, basically, she's been dizzy and having terrible headaches, so she went into her doctor, Dr. Johnson, who's under the contract with Qual Health, and he diagnosed her with TMJ, gave her some prescriptions and rehab, told her she'd be fine. She asked him twice after it wasn't working, wasn't helping. Twice she asked for a referral to a specialist, and he refused. And you know how the capitation contract works with doctors referring you to a specialist?
Yeah, of course.
Okay, cool. So, you know, obviously he didn't want to refer her to a specialist because that's expensive for him. So she called Qual Health on her own, and they told her she needed the doctor referral.
Don't you just love it when doctors spin you in circles like that?
I know. Well, she didn't love it. She's suing because after that, she went straight on her own to a specialist, and they found a brain tumor that had to be surgically removed.
Oh my gosh, that's terrible.
Yeah, and the worst part is the doctor told her that if he had found it earlier, you know, if she'd been referred there earlier and they'd caught it on time, they could have avoided the whole surgery and just used steroids. So instead, she had to go through surgery, she lost some feeling in her right side. It's terrible.
So, what do you want me to look into? Negligence, malpractice?
No, actually, our health law department already brought a negligence case. It's just going to be kind of hard to show malpractice here. And as you know, the recovery limitation there is not huge, and we think we can get more out of it on a contracts claim.
So where are we going with this? She didn't sign a contract, did she?
No, but that's what I want you to look into. I think we have a case here for her as a third-party beneficiary.
Alright, I'll look at it.
Thanks.
Okay, first, what the heck is capitation? Oh, got it. That makes sense. So it's basically a flat fee contract between insurance companies and doctors. So the more patients are sick or need referrals to specialists, the less money the doctors and HMO make. Let's see what Qual Health's contract looks like. Okay, here we go. The provider agrees that he or she will not unreasonably withhold referrals to specialists. When any patient's condition does or may require attention by a specialist or admission to a hospital, the provider will contact the Qual Health Referral Department for authorization. Okay, let's see. No applicable statutes here. Common law it is. Midwest Dredging versus McKinney.
Hi, I'm a contractor at Midwest Dredging Company. A few years ago, we had a contract with McCainage. They had a contract with the Iowa Department of Transportation, and the DOT had done all these tests of the subsoil conditions for the dredging work, and then wrote up the plans for how they wanted McCainage to do it. Now, both of them knew McCainage needed a subcontractor, and we were unlucky enough to be the one to do that work for them. We got out there and found out that the DOT's tests were crap. There was rocks all over the place. We couldn't do a thing. So we kept trying. They kept telling us to drill. Finally, we went belly up over the whole thing. And now we wanted to sue DOT because their plans told us that we'd be able to dredge, and we weren't able to. Well, they turned around and tried to say that we didn't have a right just because our name wasn't the one on the contract. But we knew that we had a third-party beneficiary claim, and let me tell you why the court gave it to us. First, the court looked at concepts of equity or justice in deciding whether or not we could have a third-party beneficiary claim. Then we looked at the second restatement of contracts, section 302, which basically says, third-party beneficiaries have rights under a contract if the contract manifests an intent to benefit the third party. Now, this intent thing can be a little tricky to unravel, so let me explain it to you. First, it's the intent of the promisee that matters. For us, that was McCainage, because the DOT promised them reliable plans in their tests. Now, second, you have to become some kind of mind reader and figure out the subjective intent of that contracting party. To do this, you can look at the language of the contract, and you can look at the circumstances surrounding the contract. For us, It's in the contract that they would have a subcontractor for that dredging work, and obviously they needed a subcontractor. It's all over the place. Of course we have that. Now, another important thing is the difference between motive and intent, and that can be really big for third-party beneficiaries. Intent is the purpose to use a particular means to effect a certain result. That's what you need to be a third-party beneficiary, is the intent to benefit you. Motive is the reason which leads the mind to desire the result. So even though McCanich didn't put in their bid just so they could hire us out of the goodness of their heart, they did know that by putting in their bid, they would need us to do that work and complete that contract. And that's why we won our third-party beneficiary claim.
Okay, well that's helpful. Just a little construction-y. Anything more analogous? Treasury versus A&A.
I'm an anesthesiologist who used to work for Genesis Medical Center before A&A got an exclusive contract with them and unreasonably withheld consent for me to keep going. So myself and a few other anesthesiologists were able to sue on a third-party breach of contract claim because in our situation, the promisee had given express notification in the contract to the promisor that we were an intended third party.
Great. Now let's see something with a little bit more similar relationship to Fesser's case. Maybe Vogan versus Hayes appraisal?
Hi, I'm Susan Vogan. When my husband and I moved to Des Moines, we decided to build our own house. We found a builder and got our loan and got an appraisal to, keep track of everything and make sure that we weren't paying for more than we were getting. Well, they didn't do a very good job. And then they tried to say they didn't know the appraisal was supposed to benefit us. Hello, it's our property, our name's on there. Of course, the parties to the contract intended to benefit us. Alex, what you got for me on the Fesser case?
Alright, here it is. There's a good case that seems to say the court takes into consideration equity and justice, but that might be limited to the construction. The second restatement really helps us though. According to common law, a third-party beneficiary has rights under a contract where the contract was made with the intent to benefit them. Now I had to upload when intent was a little bit, but basically we need the subjective intent of the promisee at the same time they made the contract. So that would be Qual Health. It gets a little tricky because Qual Health obviously didn't put the reasonable referral clause in the contract just out of the goodness of their heart to benefit Fesser. But then again, motive and intent are not the same thing. We need to prove that even though Qual Health's motive may have been to save money from referrals, they had the intent to benefit Fesser. I mean, what's the point of a health insurance policy without patients, right?
Right. Okay, I think I can flush that out of the deposition. Thanks. I'm here representing Dr. Johnson. How are you doing today, Mrs. Contract Writer for Qual Health?
I'm doing okay.
Good. Now, as I understand it, you've had problems in the past with doctors over-referring patients to specialists. Is that right?
That's right.
So, what did you do to overcome that?
We implemented the holdback system.
Right. And what was the public reaction to that?
Well, they weren't very happy. They accused us of withholding care just for profit.
So, what did you do to appease the public?
Well, we added the reasonable referral clause to their contracts.
So you're saying you added the reasonable referral clause to your contract for the sole purpose of maintaining your reputation?
That's right.
Great. Thank you, Mrs. Qual. Hi, Ms. Qual. I have a few questions from the injured Miss Fesser, if you don't mind.
Okay.
So, how exactly does Qual make money?
Well, we provide health insurance for corporate employees.
So, your company exists for the purpose of serving patients with your insurance coverage?
Well,
so when you put that reasonable reference clause in the contract, your motive was to repair your reputation by giving those patients that you exist to serve the right to reasonable doctor referrals. Is that right?
well, yeah.
But you don't benefit financially at all from the doctors giving those referrals, do you?
No, we actually lose money.
But you didn't write that as an empty, meaningless clause, right? You're not that careless.
No, we mean it.
So the only benefit that you get is to your reputation, and you only get that benefit by benefiting the patients?
Right, I guess.
So your intention was to create more legal protection for the patients that you exist to serve under these kinds of contracts, right?
I guess it was.
Great. I'm done here.